get through it in the next while, unless you want to have a break of any kind, anybody.
So Chair, I
Please.
don't think we need to take a break as much as you may all want it. It is up to you whether you want to proceed with all of the items that are on the off consent calendar for the penalty waivers.
Yeah,
Or reductions. They can be held over to the July meeting if you would like.
let's proceed. Let's see how far we go with holding those over.
Okay,
That's okay
so
with you.
proceed to skip over those.
Skip over those and we'll bring those back next meeting unless we happen to have, unless
Put them at the end.
we have some other stuff we need to discuss, at least for the
Yeah.
record, in the following. Stipulated final orders 49 through 52 have been removed, so the next, and
So we did all the rest, so it would
did we
be,
do 53 and
We did.
54?
we did, so
did
it would
those.
be item 58.
Thank you, I'd forgotten that particular part, so the next step would be item 58, which is that proposed advisory opinion, which will recall, you'll recall to your mind the past here a little bit perhaps. And the executive director will make this report.
No, Casey, did.
Casey Fenstermaker will.
That is correct.
I know it says me, but
We have two Susan Myers in our midst. Go ahead, please proceed.
Thank you, Chair Fiscom. This is Casey Fenstermaker for the record. Item number 58 is a commission advisory opinion issued at the request of Leonie Reeves, counsel with Miller Nash on behalf of Oregon State University. The opinion was requested by OSU to determine whether their student body, the Associated Students of Oregon State University, also known as ASOSU, and more specifically ASOSU's Judicial Council, is subject to public meetings law. ASOSU's Judicial Council is the branch of ASOSU that interprets their constitution and statutes. The request also asked if the Judicial Council is subject to public meetings law, whether all meetings were subject to public meetings law or only specific meetings. Finally, the request asked whether the Judicial Council's proceedings are judicial proceedings exempt from public meetings. The draft opinion in your meeting books concludes that ASOSU as a whole is a public body based in part on its shared responsibility with the university to govern the OSU students. Further, it concludes that the Judicial Council, as part of ASOSU, is a governing body subject to public meetings law due to its structure and its responsibilities. As a governing body, all of the Judicial Council's meetings are subject to public meetings law unless the specific circumstances of the meeting itself meet one of the permissible exceptions. Finally, the opinion concludes that because neither OSU nor ASOSU are part of the judicial branch, their meetings are not judicial proceedings exempt from public meetings law. The draft is ready for your consideration, and I'm happy to answer any questions that you may have.
Thank you. Good work to bring this to some form of conclusion tentatively. Any comments on the advisory opinion, colleagues? You remember the comments from the OSU people on Leonie Reeves from Miller Nash. This, if adopted, would conclude those discussions. Comments, questions, concerns? Hearing and seeing none, pardon me, Mr. Burke, please.
Thank you. Very rapidly. I think this is an excellent opinion. I support it completely. I know that student governments are venues of learning, but they also have impact on the student body. And so having been in student government myself, I think it is good that there'll be accountability there as well as in the other public offices we work with. That's all.
Thank you. You ready for action on this? I assume the answer is yes. Vice Chair, please, a motion on advisory opinion number 25-137A.
I move that the commission adopt the advisory opinion in case number 25-137A as presented.
Thank you. Questions, comments? Hearing and seeing none, the administrator will call the roll. Item 25-137A.
Commissioner Mettler.
Aye.
Commissioner Mason.
Aye.
Commissioner Burke.
Aye.
Commissioner Thompson.
Aye.
Commissioner Payne.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Next item is number 59. Who's reporting on that? This will be our former executive director, pardon me, our current executive director, Susan Myers.
Life of the beginning.
5925-291, please proceed.
Thank you, Chair Fusco. So, this proposed commission advisory opinion was requested by an attorney for the North Wasco People's Utility District. The district has statutory authority to provide stipends to their directors, the members of the board of directors. And they have done so per a governance policy that was adopted in prior years. In November of 2024, they adopted a resolution to amend the governance policy to permit the stipends to be adjusted per a consumer price index that was selected. The question that is presented is, given that the governance policy, that they have statutory authority and the governance policy was adopted per resolution, can the members of the board of directors accept the CPI adjusted stipends as part of their official compensation packages without violating 244.040? And so the answer is set forth in the opinion. We actually already gave the advice, but they wanted a commission advisory opinion because of the additional safe harbor it provides. So the answer is that, yes, the provisions in the exception 244.040 subsection 2A would apply and permit the current and future directors to accept the CPI adjusted stipend.
Thank you. Any comments or questions about this draft advisory opinion? Hearing and seeing none, Vice Chair, please, item 59.
I move that the commission approve the advisory opinion in case number 25-291A as presented.
Heard the motion, administrator will call the roll. Item 25-291A, please.
Commissioner Mason,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Commissioner Mettler,
Aye.
Commissioner Payne,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Okay, forging ahead to correspondence that doesn't require action, I'm going to exercise my prerogative and simply refer to a couple items for brief explanations here. The first, and others can ask for others beyond mine, but I want a quick discussion, explanation from Director Myers on item 63, the letter to the governor's office. Please just summarize that in a few seconds.
Very briefly. Thank you, Chair Fiscom. This was a letter in response to that Secretary of State audit. So they sent the audit info to us. And back in, I believe, originally in January and then in April, you asked for some additional inquiry review before bringing it back to you in April. And so this was simply the follow-up to the governor's office.
Thank you. And I, for one, thought we needed to say something for the record rather than just simply let this die for inaction. So some of the things I'm going to mention in the next little while relate to issues that have been of media attention, so it's worth us knowing about them, to which end I would ask the director to talk briefly about item 65.
Yes, item 65 was a letter of advice requested by the Department of Administrative Services regarding whether their existing statutes and policies about Mahonia Hall, it badly needs some construction remediation work. And so, given that the governor and her family lives in Mahonia Hall, they were asking whether they could rent additional property for them while the construction work took place.
Temporary housing, which is by the bottom line of this document that you've written, is it is allowed, in fact. Any questions or comments on that, colleagues? Okay, briefly, let's turn to miscellaneous items. Again, the important information here that doesn't require a long explanation. The first is number 66, a letter to the League of Oregon Cities. Just know that along with Vice Chair Payne and the executive, we have met online with the league and in response to concerns about various aspects of things, and we're in the process, I would submit, of putting things back together from the standpoint of mutual trust. More steps to be taken. The letters in your documents today for this meeting explain both the first letter that we got from League of Oregon Cities as well as our response to that. Be happy to answer any questions about that anybody has, as would the director. The implications of how we deal as a state agency with LOC also relate conceivably to Associated Oregon Counties, special districts, Confederation of Oregon School Administrators, and if I'm missing somebody, I don't mean to. That's because all of those persons in those associations are in fact public officials, and we need to deal with them for purposes of training as well as other issues. So I would encourage you to read the League of Oregon Cities Information Executive.
And I would simply add one, when I was promoted into this position, it is my goal to reestablish effective working relationships with all of the varying organizations. And I will continue working toward that. In terms of the League of Oregon Cities, after our meeting with them in May, we have had an additional meeting with Casey and I and the director and their general counsel, and we are working on trying to provide some additional guidance or a quick reference or some FAQs for serial communications, because that clearly is an area that people struggle with. And then we will, in future meetings, continue working with them on the training assessment process and seeing what options we have there.
Quick parenthetical, the serial communications public meetings issue was one that was a concern of that organization. I don't mimic their concern, but I have my own uncertainty about how all that works. And I think one objective that I had among, I don't know if Vice Chair had this too, but was to get a kind of a one-pager type thing, which in, pardon me, not legal language, but common sense language explains the rationale. Because some League of Oregon Cities officials who were in trainings assumed that they couldn't talk to the media or to their constituents at the risk of a serial public meetings law violation. And that wasn't the case, isn't the case, wasn't meant to be the case. So it's confusing. And I think there's a way to clear up that confusion. Further, we have the idea of being able to potentially, we're not sure if it'll happen yet, go to the legislature jointly in 2026 and/or 27 to fix the public meetings law in a variety of ways, subject to our alerted counsel saying we have that ability to do, subject to holding bodies accountable, not individual members of those bodies accountable. So we'll hold open that possibility.
Of course.
Any questions, comment? Vice Chair, are you okay with things? Nod your head, yes, please.
Mr. Chair, are you saying that a public body could all write letters to the editor, and that would be that would or would not be a serial meeting?
Well, that, or if you advocated that, you'd probably be violating, if you were registered as a lobbyist, you'd be violating some of our investigator standards.
That's true. It's the whole mess.
Okay, moving on quickly. Can we delay the own motion thing a little while, or do you want to talk about it?
We can delay the own motion to a future meeting.
And the commission meeting schedule, you've seen that. We need to vote on that. Commissioner Mason and I are advocating for weekly meetings next year when we'll be gone. Kidding. That's a joke. That's a joke.
When we're gone.
Shanoa. We've laughed. Okay, I'll take a motion
No
to
one's
adopt.
laughing.
I'll adopt the commission meeting schedule as presented to you in your booklet. Vice Chair, please.
I move that the commission adopt the 2026 commission meeting schedule as presented.
Thank you. You've heard the motion. The administrator will call the roll item, the commission meeting schedule, please.
Commissioner Burke,
I say aye.
Commissioner Thompson,
Aye.
Commissioner Payne,
Aye.
Commissioner Mettler,
Aye.
Commissioner Mason.
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Two more items, colleagues, trainers report. Can we let that stand as written, or do you want to make a comment on that, Ms. Hefner
It can,
or staff?
yeah, it can stand as written for the most part. I do just want to highlight two things.
Please.
One is, and it is in the report, Klamath County Fire District 3 did complete their public meetings law training. They did have a case before all of you. That is why multiple cases, which is why I'm bringing it to your attention.
Good.
And also we had over 150 attendees between the two sessions for the state boards and commissions training that we offered in partnership with the governor's office.
Good work. Executive Director's report, please.
So I will condense it into two pieces of good news. Our budget bill, number SB 5522, has been passed by both House and Senate and is awaiting the governor's signature. Item number two, our other two bills, HB 2930 and HB 2932, also have passed the House and Senate and are awaiting the governor's signature.
Any questions for our executive on matters not covered orally? Hearing and seeing none. Anything else for the agenda today?
It's up to you whether you want to go back and try to do the off consent or if
What's
you're ready to end and want
what's
to
your
wait
preference?
until July.
Does it matter to you?
Doesn't matter to me.
No, I mean, if it matters from a timing standpoint, given the clocks that we deal with.
It doesn't matter for the clocks. It's hard to predict what the July agenda will be. I mean,
Let's deal with that when it arrives, with all due respect. Easy for me to say, harder for you to do. That's why I don't get paid for this, just so you know.
And then when the next meeting's 3 o'clock,
yes.
so I think you can yell at him.
Just keep rolling it forward.
Okay, colleagues, thank you for your patience with the long agenda today. Thanks for all the
Very much.
reports made. Appreciate all the work that all of you have put in over the months, weeks, and in a couple of cases, years. Thank you and have a nice weekend. We stand adjourned.
Thank you.
Okay. Take care, everyone.
Thank you.
Thank you, Richard.